You know the scene. Maybe you've lived it. You're driving home, the rearview mirror flashes red and blue. You pull over, kill the engine, and roll down your window. The officer steps out, adjusts their belt, and asks a simple question. Do you know why I pulled you over? Or maybe it's not a car. Maybe you're at your front door, and a detective in a windbreaker hands you a business card. Mind if we come in and ask you a few questions? Maybe it's a workplace security officer, a campus investigator, or a plainclothes officer at a local park. The setting changes, but the psychological trigger stays exactly the same. They ask you something casual, something conversational, and your instinct, the deeply human, deeply American instinct, is to answer, to clarify, to explain, to prove you're not a threat, to show you're cooperative, to clear the air. Here is the hard truth that television dramas, pop culture, and even basic civic education routinely obscure. You are not having a conversation. You are participating in an evidentiary mining operation. The legal reality of police questioning operates on a completely different frequency than everyday social interaction. When an officer asks you a question, they're not looking for context. They are collecting raw material. Every syllable you offer, every timeline you volunteer, every nervous clarification you drop is instantly logged, time-stamped, and evaluated for how it can fit into a prosecutorial framework. This brings us to the core legal paradox. The very behavior we're taught to associate with good citizenship, cooperation, transparency, polite explanation, is the exact mechanism that strips away constitutional protection. The system tells us that talking builds trust, but legally, talking without counsel builds the case against you. The paradox isn't that police are trying to trick you. It's that the rules of the street and the rules of the courtroom operate on entirely different tracks. Your good intentions do not translate into legal immunity. In fact, in American jurisprudence, your explanations are treated as voluntary statements, and voluntary statements are admissible evidence. You don't have to be guilty to get caught in this trap. You just have to be human. You just have to assume that honesty equals safety. The Fifth Amendment right to remain silent isn't a loophole carved out for the guilty. It's a structural firebreak. It's the constitutional mechanism that forces the state to carry the entire burden of proof without you accidentally handing them the bricks. Over the next few minutes, we're going to dismantle the myths surrounding police questioning, map out the exact legal doctrines that govern these interactions, and give you a clear, repeatable strategy to navigate questioning with dignity, clarity, and unshakable constitutional awareness. This is educational content, not legal advice, but it is a necessary blueprint for anyone who wants to walk through the modern legal landscape with their rights fully intact. To understand why silence is legally strategic, you have to understand the three foundational doctrines that actually govern how courts treat police questioning. Forget what you've seen in procedural dramas. The law operates on precision, not drama. The first concept is the Fifth Amendment privilege against self-incrimination. At its core, this amendment establishes a foundational rule of American justice. The government must prove its case, not the citizen. You are not required to assist investigators in building a case against you. But here's where most people get lost. The privilege doesn't mean you have to shut down, get aggressive, or refuse to provide basic identifying information in certain contexts. It means you cannot be legally compelled to offer testimonial evidence that could reasonably be used to establish your guilt in a criminal proceeding. Think of it like a locked vault. The state has to pick the lock using independent investigation, warrants, and witness testimony. You don't have to hand them the key. When you voluntarily start talking, you're essentially cracking that vault yourself and inviting them to sort through the contents. The second concept is the custodial versus non-custodial interrogation distinction, which directly controls when Miranda warnings are legally required. Pop culture teaches us that an officer must read you your rights the second they speak to you. That's legally false. The Miranda trigger only activates under two simultaneous conditions. You must be in custody, and you must be subjected to interrogation. Custody legally means a reasonable person in your position would not feel free to terminate the encounter and leave. If you're pulled over for a routine traffic stop, or an officer is asking you questions on the sidewalk, courts generally classify that as non-custodial. That means no Miranda warning is constitutionally required, and everything you say is fully admissible in court. The moment you step into the back of a patrol car or enter an interrogation room, the calculus shifts. But until that shift happens, you're legally speaking in the open. Your words are fair game, even without the famous warning. The third and arguably most dangerous misconception is the explicit invocation requirement, solidified by Supreme Court rulings like Salinas v. Texas 2013 and Berghuis v. Tompkins 2010. Many people assume that simply staying silent is enough to protect their Fifth Amendment rights. The courts have explicitly rejected that assumption. If you don't clearly, unequivocally state that you are invoking your right to remain silent or your right to counsel, prosecutors can legally introduce your pre-invocation silence into a trial as evidence of guilt. The court's logic is harsh but consistent. Ambiguity is treated as waiver. If you just stare at the officer, hesitate, or say, "I don't really want to talk about that," you haven't legally invoked the privilege. You've just created an awkward pause. To activate constitutional protection, you must speak the invocation into the record. You must draw the line clearly. Think of it like a circuit breaker. Flipping the switch requires deliberate, unambiguous force. Standing near it doesn't cut the power. These three doctrines, self-incrimination, custodial triggers, and explicit invocation, form the actual legal architecture of police questioning. The system doesn't punish you for staying silent. It punishes you for assuming silence is automatic, for misunderstanding when Miranda applies, and for believing that casual conversation is legally harmless. The law expects you to know your own rights. It won't remind you until it's constitutionally mandated, and even then, it's your responsibility to assert them. So why does this matter so profoundly? Because the cost of legal ignorance in these moments is rarely measured in minutes. It's measured in months, in plea deals signed under pressure, in criminal records that outlive your intentions, and in the quiet, invisible surrender of your constitutional leverage. The core fear driving most people's decision to talk is deeply human. We're wired for social harmony. We fear that silence will be interpreted as defiance. We fear that saying no will escalate the situation. We fear that we'll look guilty if we don't immediately explain ourselves. But in the legal arena, that fear is precisely what investigative pressure exploits. The tension isn't about whether you did something wrong. The tension is about whether you hand them the raw material to make it look like you did. When you trade constitutional protection for short-term convenience, you step off the legal high ground and onto a slippery slope. You start explaining your whereabouts. You start clarifying a minor detail. You start trying to clear things up. But in a deposition or trial, that clarification becomes a point of contradiction. The timeline shifts by 10 minutes. The address is slightly off. The tone of your voice on a body cam recording suggests nervousness. Prosecutors don't need you to confess. They just need enough voluntary statements to create a mosaic of suspicion, enough to justify a charge, enough to pressure a plea. That is the invisible cost of untested assumptions. You think you're cooperating with authority, but legally, you're authorizing your own prosecution. This is exactly why the framers built the Fifth Amendment. They understood a fundamental truth about power and human nature. As Justice Sonia Sotomayor has noted in her writings on investigative overreach, the privilege against self-incrimination guarantees an individual the right to remain silent unless he chooses to speak in the unfettered exercise of his own will and to suffer no penalty for doing so. The constitutional design is deliberate. It recognizes that power asymmetry is inherent in police encounters. The state has resources, training, legal backing, and recording technology. You have your voice, your instincts, and your rights. Sacrificing the latter for the illusion of immediate comfort is a civic mistake. Navigating police questioning correctly isn't about hostility. It's about recognizing that the Constitution doesn't expect you to out-talk a professional investigator. It expects you to step out of the evidentiary stream. You are not sacrificing courtesy when you remain silent. You are honoring a 200-year-old structural safeguard designed to ensure that liberty isn't eroded by convenience. The weight of this right is heavy, precisely because it stands alone. No one else in that encounter is incentivized to protect your future but you.
Let's ground this in reality. The legal principle remains constant, but its modern manifestations vary wildly across your daily life. Below are 6 common scenarios where legal myths collide with actual rights and exactly how to navigate them with calm, de-escalating precision. Scenario 1. The routine traffic stop. Legal myth. If I answer politely and explain where I'm going, the officer will see I'm respectful and let me go. Actual right. Traffic stops are legally considered temporary investigatory detentions, not custodial interrogations. Officers can ask about destination, origin, and purpose of travel. You are not legally required to answer beyond providing identification and registration in most states. Navigation. When asked, "Where are you coming from?" or "Do you know why I stopped you?" respond with calm compliance on the administrative front, but boundary setting on the evidentiary front. Officer, I'll provide my license and registration as required. I prefer not to discuss my travel or answer questions today. Am I free to go? You remain respectful, you comply with lawful orders, you close the evidentiary door. Scenario 2. Digital privacy and device requests. Legal myth. If they're asking to see my phone, they must already have a warrant, or I'll look guilty if I refuse. Actual right. The 4th and 5th Amendments converge here. While border and certain exigent circumstances create exceptions, in standard civilian encounters, police generally cannot compel you to unlock a device without consent or court order. Your phone contains testimonial patterns, location history, and communications that extend far beyond a single incident. Navigation. I respect your investigation, but I do not consent to a search of my device, and I will not be answering questions about its contents. If you have a warrant, I will comply with the warrant's terms. Otherwise, I am invoking my 5th Amendment rights and requesting an attorney. Clear, unambiguous, legally airtight. Scenario 3. Workplace or corporate internal investigations. Legal myth. HR or corporate security is just gathering facts. If I cooperate, I'll keep my job and clear my name. Actual right. Corporate investigations often run parallel to law enforcement. Internal security may share statements with police under joint inquiry agreements. Voluntary statements to employers are not shielded by Miranda and can be subpoenaed. Navigation. I appreciate the need to resolve this internally. Given the seriousness of the matter, I will not be providing a statement until I've had the opportunity to consult with legal counsel. I'm happy to cooperate through my attorney moving forward. This protects your employment standing while preventing unfiltered self-incrimination. Scenario 4. Contract disputes, landlords, or neighbor conflicts involving off-duty personnel. Legal myth. It's just a neighbor dispute or a lease issue. The guy in plain clothes asking questions isn't a cop, so I don't need to worry. Actual right. Off-duty officers, private investigators working with agencies, or landlords collaborating with municipal code enforcement can still funnel statements into criminal or civil proceedings. The legal vulnerability isn't the badge, it's the question. Navigation. Treat the interaction as a legal checkpoint, not a casual conversation. I understand you're looking into this, but I'm not discussing the details verbally. Any communication regarding this matter should go through my attorney. Thank you. You de-escalate by refusing engagement, not by refusing respect. Scenario 5. Social interactions and public casual questioning. Legal myth. If I'm at a bar or park and someone in plain clothes starts talking to me about a nearby incident, I can just chat. It's just a casual conversation. Actual right. Plainclothes investigators and undercover operations thrive on voluntary conversations. There is no custody, no Miranda, no formal interview. Just a person asking questions that happen to be recording or being reported. Keep it polite but impenetrable. I don't comment on incidents or investigations. If you have official business, I'm happy to see credentials, but I won't be answering questions without my attorney present. You don't guess their role, you protect your record. Scenario 6. Online content, DMs, or email inquiries from investigators. Legal myth. If they message me through social media or email, it's not official. I can reply casually or delete the message. Actual right. Digital communications are legally equivalent to in-person statements. Investigators use verified social media profiles and official email accounts to gather voluntary admissions. Deleting messages does not erase them from server logs or investigator records and can trigger obstruction or consciousness of guilt inferences. Navigation. Do not reply. Do not argue online. Screenshot the inquiry, document the timestamp and profile, and immediately retain counsel to draft any response. If you must acknowledge receipt publicly, all inquiries regarding this matter will be addressed through legal representation moving forward. Then stop typing. The pattern across all 6 is identical. De-escalation through knowledge means removing emotion, removing speculation, and replacing it with consistent, repeatable constitutional language. You don't need to explain why you're silent. You don't need to justify your choice. You just need to state it clearly, politely, and repeatedly. Legal preparedness is not paranoia. It's prudence. It's the quiet understanding that rights are not self-enforcing. They are self-asserted. The goal of navigating police questioning isn't to treat every officer as an adversary. The goal is to treat every encounter as a constitutional checkpoint, where clarity replaces confusion and dignity replaces panic. Here's your practical path forward. First, internalize the invocation phrase. Say it out loud until it's muscle memory. I respect your position, but I will not be answering questions. Am I free to go? If not, I am invoking my Fifth Amendment right and requesting an attorney. Second, separate compliance from conversation. You can hand over documents, step out of a vehicle when ordered, and follow lawful instructions while maintaining absolute silence on substantive matters. Third, document the encounter the moment you're legally free to do so. Write down times, badges, patrol car numbers, exact questions asked, and your exact responses. Memory degrades under stress. Documentation preserves reality. Fourth, know when to consult a licensed attorney. If you feel the encounter shifting from routine to investigative, call a lawyer before you say another word. And finally, distinguish between caution and fear. You are not obligated to distrust the system. You are obligated to understand how it operates so you can navigate it with precision. As James Madison wrote in the Federalist Papers, if men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. The Fifth Amendment exists precisely because we recognize that power requires structure and liberty requires boundaries. The right to remain silent isn't a shield for wrongdoing. It's the assertion of innocence's oldest ally, the principle that the state must prove its case, not the citizen. You now understand the legal architecture of police questioning. You know the difference between custodial and non-custodial encounters, the necessity of explicit invocation, and the practical phrases that de-escalate while protecting your rights. Use this knowledge responsibly. Share it with someone who needs it. Subscribe for more breakdowns that turn legal complexity into everyday clarity. And remember, preparedness isn't about expecting the worst. It's about ensuring you're never caught off guard by the rules. Stay informed, stay calm, and never surrender your constitutional footing to the illusion of conversational safety. This is educational content, not legal advice. Always consult a licensed attorney in your jurisdiction for guidance specific to your circumstances.